It's Johnny Mike Garland coming to you from Chicago, as usual. And today I've got a fantastic video. It's Kim Blandino. Kim Blandino's attorney files a motion to withdraw because, of course, Kim is not cooperating with him. And it's a great hearing. I got it from our Nevada judges. It's from Alex over there. I just did a stream with Alex and Natalie Lawyer Chick and Artie's Corporate Fiction, and it was a lot of fun. I'll put a link to that in the description below. I'm going to warn you right here, this isn't that long, but it's kind of dense in terms of issues, and I'm going to talk all over it. So if you want to see the video without me interrupting it, because I'm going to interrupt it, if you want to see it without me interrupting it, go over to our Nevada judges. I obviously put a link to the source video. I always do in the description, and you can see it without that. But this presents a lot of issues, and it's just one that I'm going to talk a little bit. So let's do it.
State versus Blandino, KC 341767. Who's here for the state?
Mike Dickerson on behalf of the state, Your Honor.
Okay, and Mr. Bateman?
Yes, good afternoon, Your Honor. Ben Bateman, bar number 9338.
Okay, and Mr. Blandino, I can see him. It appears as though he is appearing via Blue Jeans, so thank you very much. I mean, I'm assuming the state's had an opportunity to review this motion?
We have, Your Honor.
Okay. Mr. Bateman, I just have a couple of questions. I mean, because I know you're indicating you have to withdraw because continuing to represent him would require you to violate the rules of professional responsibility, but I'm not sure I understand that.
Okay.
Because it's the attorney's obligation to set the trial strategy, correct?
That's correct, Judge.
Okay. And it's up to Mr. Blandino if he wants to cooperate or not. And if he chooses not to, I guess he does that at his own peril. But it's my opinion that this is just more of the same obstructing and impeding. You know, let's see how many lawyers I can go through.
Well, Your Honor. Well, yeah.
I like this attorney, and he does a good job throughout this. But his problem is he really, everything the judge is saying is making a lot of sense. His main problem is that his client won't cooperate with him and is just really hard to deal with. But everything that she said in opposition to it sort of makes sense, and he can see that the motion is likely going to be denied already. And he's in this uncomfortable position of arguing with the judge he respects, it appears to me, understanding her position, but still saying, what am I supposed to do? He won't do anything. He won't even talk to me about how to proceed. Here we are.
Yes, he is not, right. He is not cooperating. He's not, the stages of grief. He's not to acceptance stage yet that his self-representation has been revoked. He, in his letter that's attached as exhibits, the letter to Judge Bell, the writ of habeas corpus that he proposed, in it he, and I did, speak to bar counsel, in it he intends to, despite my efforts on trial strategy, Judge, to use his right to testify as a defendant, and regardless of the question that I ask, what's indicated is to bring up Your Honor's judicial disciplinary record, that sort of thing, partly to, I guess, state that he is...
You can let me worry about the evidentiary issues, because at the time of trial, the court will conduct and determine which issues are relevant and which are not. I mean, I know your concern would be questioning him if he did take the stand and testify. If at that time you represented to the court that he wanted to give testimony that was inconsistent with what you thought was appropriate, I can allow him to testify via narrative. And you would.
This is just so interesting on all levels. There's a whole bunch of things. His basis is saying I can't represent him without violating the code of professional conduct, and that could mean a lot of things. I'll give a good example. The standard law school example they always say is what do you do if your client is going to lie in the stand and tells you? You have two competing duties. One, you have a right to zealously defend your client in the case of a criminal case. Well, you have a duty. A duty to zealously represent your client. In this case, defend a client. So you're not there to do things to hurt their cause. However, if they say I'm going to get on the stand and lie, you can't suborn perjury. So now you got to pick one of those things. And if they get on the stand and lie, then I think the only thing you can do at that point is call for a sidebar, go to the judge and say, my client just lied on the stand. I don't know what else to say. I'm not taking the hit for suborning perjury for the guy. But that's just a law school example. I'm not saying that's what Kim Blandino intends to do, or even what he's referring to. But it's a myriad of things like that where he could end up with conflicts in his professional duties as an officer of the court. The other thing that's interesting, he said he wants to use his right to testify as a trial strategy. I don't know the specifics on this case, although I have some familiarity, but I don't know what his particular trial strategy. But most of the time, you don't want your client to take the stand, especially with prior convictions like Kim Blandino has. So, I mean, forget about the crazy circus he's going to start when he gets on the stand. Just the decision to testify. I think most defense attorneys would say, no, do not take the stand. We're going to defend this and say that that they've got the burden of proof and they can't prove what they're saying. And given the allegations here, there's sort of some intent requirements and stuff. That is, I think, probably the best approach. Now, I don't know. I don't do criminal defense, but I do try cases. So I have my ideas about what's going on here. My first inclination is to not take the stand, force them to prove it, and say that you're inferring intent that's not there every time they try to prove something. That, I think, is the best way to proceed, but we'll see. But anyway, so he's got problems of ethical conflicts. He's got problems of the strategy of actually taking the stand, and then he's saying he's implying to the judge he's going to try to bring up your judicial record, which is just nonsense. She doesn't have some major problematic thing. He's got a problem with every judge in Nevada. So he's just saying, the circus that's going to be on there. She's saying, don't worry about that because it's not relevant, and I'm gonna tell him to stop doing it. And my guess is he'll continue doing it, and he'll go. We'll never. I mean, he'll be held in contempt and be pulled out of the court. That's my prediction as to how this trial will go.
Not be required to ask him any questions.
Okay. Well, despite that, Judge, then
that issue, I don't want to put you in that type of a position, but I mean, Mr. Blandino is not going to testify about a bunch of irrelevant and inappropriate things. So.
He's going to try to. I have no doubt that this judge is anticipating all this. She knows exactly what the problems are. She's had him before. She was the one that revoked his right to self-representation. She's going to be loaded for bear in the sense that she knows that all sorts of crazy is coming her way, and she's gonna run a tight ship for this trial. There's no other way to do it. I'm confident in that she will do that, but it's still not a good situation.
So, I mean, you can the court.
Well, right. I mean, that's specifically right. Rule was it 4.4 that I referenced to, used to delay, embarrass, or burden a third person or disrupt the tribunal, which is Rule 3.5. But also, Judge, communication is not happening. My meetings with him are unproductive because I think the skill set, I think it's probably because I've been on this case for a while. The skill sets that I had, I guess, as standby counsel are very different than being lead counsel. And I think perhaps there was obviously I filed motions, I filed things that I would never file as an attorney for Mr. Blandino because he was his own attorney. I think perhaps there was some belief on his part that I sort of was in agreement with his trial strategy, his overall strategy, which I was not. I have my own. And so all these meetings, since his revocation, I mean, basically, are you going to do this? Are you going to do that? And basically, no, these are the things that we need to work on, and they don't happen. And so it's obviously hindered my ability to represent him and to be prepared.
That's really interesting. So while I was doing standby counsel, Kim was probably approaching him with a lot of wacky theories and motions, and he's standby counsel. He's like, sure, yeah, fine. You need to fix the caption and do this. Do this stuff to let it conform. I mean, he agreed with none of it or whatever. Now he's the attorney. His right to representation has been revoked. This guy is the attorney, Ben Bateman. And he's saying, no, we're not filing that. It has no merit. Now I'm the attorney. The answer is no. And it's precisely why the judge is keeping him on. We'll get here in a second that he wants to call another judge as a witness, which is crazy. And again, he's in charge of trial strategy. So he's just saying, no, we're not calling that witness. He can't prevent him from getting on the stand and testifying, I don't think. But everything else, he can just say, no, that's not how we're doing it, Kim. That is not how we're doing it. I'm the attorney. You're not the attorney. Your right to suffer representation has been revoked, and I do not choose to call that witness. The end.
Additionally, he said things in these letters that he made public to Judge Bell, and in his writ, attributing statements to me that I've never said. That you were, I don't know. One was that you were irredeemably biased. That I'm undecided if I'm going to call Judge Bell as a witness. There's no doubt I have never wavered that I'm not going to call Judge Bell as a witness in his trial, or that I won't file any pretrial writs. The writs that he he wouldn't file when he was his own counsel. I'm not obligated to file those now that I'm counsel because I believe they're meritless. And so, Judge, this is where we're at. That I'm not really getting any help from him. Obviously, I know he's been, he believes that he needs to be his own attorney, and that his right to self-representation was taken from him unfairly, and therefore he's not cooperating with me. I don't know if I know Your Honor is loath to continue this or even stay this till his remedies are exhausted. I don't know but I think I do. We're at the point where I feel it's necessary to withdraw because I'm not getting anywhere with him.
Mr. Bateman, let me just interrupt right now. First of all, I have confidence in you. You're an officer of the court, that you're going to comply with all the rules of professional responsibility. I'm not worried about that. What I am worried about is Mr. Blandino continuing to obstruct and impede the state from going forward. So if he continues to choose to not cooperate, he does so at his own peril. But obviously, you're the attorney. You get to determine trial strategy. And so, again, if he fails to cooperate, he fails to cooperate at his own peril. I mean, I don't know what else to say. There will be nothing different if I appoint another attorney. It would be the same thing over and over and over again. So his self-representation, I have revoked that. He is now represented by counsel. I know he's not happy about that. I know he objected to that. That objection is noted in the record. It's preserved for any appellate review. But I have to tell you, I'm not inclined to grant the motion to withdraw based on what's in front of me. Anything else?
All right. No, Your Honor.
I mean, again, I just want to thank you for your willingness to do this case. I mean, I understand the position you're in.
I don't know. He just filed a motion to withdraw. He's kind of not willing to do it, but he's now obligated. So now there's nothing he can do. He's now the attorney. I'll tell you how I would defend this case, and I'm not a criminal defense attorney, so yeah, everyone else can jump on me or whatever. But here's the broad outline of how I would defend this case. I would say, look, this whole thing, I'm just going to attack the state's case and say they haven't met their burden where I can, and I would tell him not to testify. Most likely, I'm not that specific on the case. If he's going to testify, I would say don't say this, that, or the other thing. And if he does, then he does. Then he's going away, and he's going to be convicted on everything. And if he keeps doing crazy stuff, he'll probably tack some contempt on top of it, or whatever charges he's convicted of. And then I'll say, what are you going to do? I told it, he got on the stand against advice of counsel, and he testified against advice of counsel. And he got convicted, and I would not lose 5 minutes of sleep over it. This motion is also interesting because I actually really have a lot of respect for the attorney and for the judge. They both make a lot of sense. Ben kind of knows he's not out there, but I think half the purpose of this motion is here's the warning shot and just a public airing of what I'm up against. Of course, the judge already does know what he's up against because she's dealt with it. I think if as much as anything, this is to make a record that this is not what he wants to do. I think he probably suspected that the motion would be denied, and that the strategy that I outlined is not only, I think, a decent one. It's literally the only one available that I can see. So I'm not going to call your crazy witnesses. I'm not going to file your meritless motions. I'll file something if I see it, if there's some good reason, if there's a motion to suppress, or we're past that. But I'd file that. But I'm not. If you come to me with some crazy theory, I'm just not filing it. So that would leave him with just spouting whatever he wants to when he's on the stand. She's saying she's going to let him testify narrative. In other words, that he wouldn't have to ask questions, therefore not suborn perjury. But and then he'll go rambling on. But at some point, she'll say, "You got to cut this off. You got to get to a point." So I think that sets up for sort of an interesting trial where you'll have some rambling testimony from Kim Blandino in the middle, and the rest of it would be him just poking holes in the state's case. That would be my guess. It'll be fascinating if this trial goes. I really hope to see it. Although I'm confident Alex will get the video of that because he's great with that stuff.
It's up to Mr. Blandino to determine whether he wants to cooperate or not. And again, if he chooses not to, he does so at his own peril. So, does the state want to be heard at all?
All right.
Mr. Dickerson?
The only thing that I would say is my assessment of all this, Your Honor, is that this is something that doesn't appear to be unique to Mr. Bateman or only him.
Exactly.
I have sympathy for him in this situation, but I think that this is going to be any defense attorney in his situation.
Right. I mean, and that.
Yeah, absolutely. I mean, he's just echoing what she said, and he's right, of course. And that's why the judge is denying it, because appointing another attorney, I mean, this is a guy who's filed motions to remove every judge in Nevada. Let me assure you, he will have no problem filing a motion to get rid of every attorney that's ever assigned to him. Of course, that's coming. So you just have to cut it off at some point. Ben drew the short straw on this one. I think he's a fine attorney. It's frustrating for him because he's sitting there looking at the facts of the case and saying, look, if you'll talk to me and do this, I might be able to do some good for you. That's my guess. That's what's really frustrating. As an attorney, he can't do his job. He's like, yeah, they got some problems that I can help you with, Kim. And he's like, no, I want to do it. There you go. So it'll be a fascinating thing to see.
The opinion of the court that it wouldn't matter who was appointed. We would have the exact same issues. I mean, we're close to trial. We're less than 30 days out for trial. So at this time, I'm going to deny the motion to withdraw.
All right.
Charcuterie Fall, page 13.
Thank you, and thank you for your patience.
Thank you.
Well, there you have it. You know, the judge, you can see why she doesn't want him to withdraw right there. Kim wasn't able to speak. It was his motion. There was no reason for Kim himself to speak. That's what she likes, because he isn't going to say anything relevant around the issues. He's just going to start another circus, and that's what she's trying to avoid. So and also, you know, getting new counsel. If he got another new attorney right now, it wouldn't be fair to make him go to trial on February 28th. Absolutely not. And that's why they do it. And it's a very common tactic for this type of defendant. I mean, he isn't the first guy to try to get rid of all his attorneys just to waste time and delay the trial, which appears to be exactly what's going on here. You never know. But it'll be interesting to see if that trial goes, and it's certainly interesting if it does on February 28th. Here at Law Talk, we like to have fun with silly stuff that happens in court, and every once in a while, and completely by accident, I assure you, you might learn something. Thanks for watching.